litigation as well as I've had this opportunity to work with Sir. I'm really glad. He's such a great mentor for all of us. Thank you, sir, for being here today. So I'll now proceed to explain the time division which is granted to each counsel in a single team. Okay, each team is allocated 30 minutes to present their case. Each speaker will be given 15 minutes each unless indicated otherwise by the team. So there are placards which will be indicating the time shown, that is 5 minutes prior, 3 minutes prior, and on the lapse of time which is allocated to the speaker. And rebuttals will be left on the discretion of the judges. So I request Meghna to introduce the speakers.
We have team Kanisha K and Sukrita A arguing on behalf of the petitioners, and team Mahi Singh and Shrey Bhatnagar arguing on behalf of the respondents. With the permission of our learned judges, we shall commence the semi-finals round of the 4th National Virtual Moot Court Competition. I also request the judges to please give feedback to our speakers after the rounds prior to the marking to help improve their performance in the upcoming round.
You may start the program in the competition.
Thomas sir, I think with your permission, let them not waste the time in explaining the case details and all.
Yes.
Because both the parties know, even we know about the facts.
Yes.
And the first team could be wasting the time in explaining this thing. Let them directly get into that.
Yes. I only wanted to have one small word to the participants. That is, rebuttal is permitted for the petitioners if it is so that the respondent also want to rebut. Sir, what do you say?
I don't think, sir, as per the procedure, only petitioners will have a rebuttal unless we permit the respondent also give a clarification, anything we ask for them.
Yes, yes.
Subject to your action.
Sure. So this is made clear to all the participants.
And all the best, both the teams, and be free and good luck.
Wish you all the best. Go ahead.
The council takes permission to collectively address your lordship. This is council number 1 on behalf of petitioner in the case of Jansiva versus Union of India. If the lordships
your voice is not clear, Amma. Anisha, your voice is breaking it.
Is it audible now, sir?
Is there a fan working behind you? If the fan is working, just off it, because we are having a breeze sound.
Yes. Sorry, sir. Sorry for the inconvenience.
No issues. Go ahead.
If the lordships are satisfied with the facts of the case, the council humbly seeks permission to brief the issues that is raised by the petitioner.
I only want to have a clarification. How Janseva is entitled to go for this PIL?
Janseva is a registered NGO, and they are fighting for the rights of the public, because the rights of the public are affected in the present case, your lordship.
So under what constitutional provision in the constitution you are filed this PIL?
Article 32 of the Indian Constitution, your lordship.
Okay, go ahead.
Your lordship. The issues that is raised by the petitioner is, first issue is whether writ petition is maintainable. The second issue is whether the office of the speaker satisfies as the independent adjudicatory machinery. The third issue is whether the inclusion of 10th schedule in the constitution is violative of the basic structure doctrine of the constitution. Fourth issue is whether the 10th schedule violates the rule of law under Article 14, 19 and 21 of the Constitution. The council number 1 will deal with the first and second issue. The council number 2 will proceed with the third and fourth issue. If the lordships permit, the council would like to argue for the first issue.
Please go ahead.
Much obliged, lordship. The first issue being whether the writ petition is maintainable. It is humbly put forth by the council on behalf of petitioner that this PIL has been filed under Article 32 of the Constitution, and there is an infringement of fundamental right due to the inclusion of 10th schedule into the Constitution. A PIL can be filed, that is with regard to that Article 32 of the Constitution for the enforcement of fundamental right. Also, it is important to note that, Your Lordship, the scope of locus standi has been increased from an aggrieved party to any person fighting for a proper cause. Thus, here the petitioner has sufficient grounds to prove that there is an encroachment of fundamental right and he has sufficient locus standi. Also, the council would like to mention that the 10th schedule has not prevented defection. Rather, it gives a way for more defection through the loopholes of the anti-defection law. Thus, it cannot provide a stable government for 37 years and the government is not accountable to its people. Thus, the council would like to put forth that this anti-defection law affects the basic structure of the constitution. This cannot be ignored that the law is no longer res integra. That means res integra is an entire thing or entire newly thing or an untouched matter. Here, anti-defection law creates an unstable government and it affects the basic structure of the constitution. Thus, the petitioner humbly pleads that this petition is maintainable. If the lordships are satisfied with the first issue, the council would like to continue with the second issue.
Go ahead.
Shall we ask the questions at the end of the session, or should we continue with this?
As and when required, we can clarify and proceed.
Fair enough. Fair enough.
Yes. Sir, you can go ahead if you have got some clarification to be made now.
Yeah. The council used spoke about the basic structure.
Yes, Your Lordship.
What is that issue in this particular provision of law? You are thinking that the basic.
Here, the council would like to put forth that Article 14, 19, 21 of the Constitution is considered to be the basic structure of the Constitution because this anti-defection law affects the basic structure of Constitution. The council puts forth that this writ petition is maintainable, Your Lordship.
Could you please clarify what is this basic structure?
Basic structure doctrine is said to be the main foundation of the democracy. That is, when with regard to parliamentary democracy, accountability is said to be the main feature. If this is affected, then the basic structure is affected, Your Lordship. The basic structure is elaborately discussed in Kesananda Bharati case, where it stated that supremacy of the constitution, parliamentary form of government, and all other matters are said to be the basic structure of the constitution. An amendment cannot be made to the basic structure of the constitution, Your Lordship.
Then how come Schedule 10 has come?
Schedule 10 has came to curb the defection, but as it violates these articles,
No,
the council...
I'm asking how come this Schedule 10 has come into picture?
Through 52nd Amendment to the Constitution, Your Lordship.
Can that be done? Because the basic characteristics is being violated, isn't it? With this schedule coming into picture.
This is the reason that now the council is arguing on behalf of petitioner, Your Lordship.
Go ahead.
Yes, thank you. Much obliged, Lordship. The second issue being whether the office of the Speaker satisfies as the independent adjudicatory machinery. The Council would like to argue this issue with two sub-issues. The first sub-issue being whether paragraph 6 is violative of the rule of law. It is humbly put forth that an independent adjudicatory machinery for resolving disputes regarding the competence of members of the House is an attribute of the democratic system, which is the basic structure of the Constitution. Here, the Speaker or Chairman is said to be the presiding officer when it comes to the disqualification on grounds of defection of the member of the House, and their decision is said to be final. This is said in the paragraph 6 of the 10th schedule. Also, the rule of law, which is stated in the Article 14, is a basic structure to the Constitution. It cannot be destroyed by an amendment. Thus, the Council humbly put forth that Article 102 and 191 states that whenever a disqualification to a member is decided, the President or a Governor is given an opportunity to decide regarding disqualification of a member. Thus, an independent member is given in this case. Also, it is humbly put forth that all disqualification, including defection, sorry, all disqualifications, including disqualification by defection or different species of the same genus. Thus, they does not contemplate any difference in their basic traits and treatment. That the council would humbly put forth that the power that is vested with the speaker is against the intent of the constitutional maker, as the authority is given here to decide the disputes that is regarding the disqualification of a member is dealt outside the how that is it is given inside the parliament or inside the state legislature. Article 103 192 states that an independent authority outside the election commission like president or governor in accordance with the opinion of the election commission is given an opportunity to decide with the disqualification cases. Also, the council would humbly put forth that the Dinesh Goswami committee recommended that the power to decide disqualification of defected member has to be given to a president or governor of the state who shall act on advice of the election commission. Also, the council now would like to state the case Kesham Mahendra Singh versus Speaker. The council seeks permission to screen share the compendium. Your lordships.
Before
Yeah,
you
please.
go into that,
Yes,
sir,
your
go ahead,
lordship.
sir. Go ahead,
No,
sir.
no,
You
it's
were
all right.
asking-
No,
you were
no,
asking
please, sir,
something.
you ask that question, then he can proceed.
I only wanted to say, I wanted to clarify from you, council, that when 10th schedule is being there, and this is
Yes.
in the 10th schedule, and 10th schedule is in line with the constitution, and it is not clashing with the constitution. How do you say then this is wrong?
Because the council would like to state that the main intent of constitutional maker is to give an opportunity to a person like president or a governor outside the parliament or a state legislature. This is the intent of the constitutional makers
This
while
is also
creating.
something. This is also something within the legislature, right?
Yes, your lordship. This defection also comes under disqualification of a member. That is also should be considered along with Article 102, your lordship.
No, just
If
now you said it's outside the uh, parliament. But
yes,
what
the
I am trying
decision
to say is
is
this legislation, this happening is inside the legislature, isn't it?
yes, your lordship. When legislation is made inside the parliament, I think there comes loopholes to the law, your lordship. There is misuses regarding this 10 schedule, your lordship.
Okay, go ahead.
I think,
Much
Madam
obliged.
yeah,
Courtmaster, kindly grant them 2 minutes extension because I have to take some time.
great. Council,
Much
I think
obliged.
your basic argument is that the defection part should be dealt by the governor and president, not by the speaker, correct?
Yes, your lordship, and also would like to also mention with the case law Kesham Singh, it has been said that a permanent tribunal by a retired judge can also be an independent person with regard to disqualification, your lordship. That is the argument that I would like to put. Not only president or a governor, other any independent person can deal with this issue. Also, if the lordships permit, the council would like to proceed with second sub issue, your lordships.
I think you told that on screen, you want to put it on the screen on the
Yes,
which part of the judgment,
Akesham Singh, your
which
lordship.
judgment.
Can I
Yeah,
proceed,
please,
your lordship?
please.
So, if the is the screen shared, your lordship?
Kindly
This is the case.
slightly zoom it. Go
Yes, your
ahead.
lordship. This is the judgment that is given in the Kesham Singh where they have stated that Parliament should consider serious amending to the Constitution to substitute the Speaker of the Lok Sabha or Legislative Assembly as arbitrator regarding the disqualification cases. A permanent tribunal headed by a retired Supreme Court judge should be given an opportunity to decide these disqualification cases, Your Lordship.
This is Supreme Court or state? Any state?
Supreme Court judgment, Your Lordship.
Okay. Yes, go ahead.
This is with regard to which part of the state India, this Indigo?
Kesham Singh deals with Manipur Legislative Assembly, Your Lordship.
Fine.
Much obliged, Lordship. Now the council would like to argue for the second sub-issue whether paragraph 6 is violative of Article 21 of the Constitution. It is humbly put forth by the council that procedure that is established by law should be fair, just, reasonable, and not oppressive or arbitrary in nature. The procedure that is the chairman is said to be a nominee of a political party, and he is also not obliged to resign the political affiliation. This speaker's tenure is wholly dependent on the majority will of the House. Thus, his decision is highly suspected to be biased. The council would like to mention an example with regard to tenure, Your Lordship.
Go ahead.
The council would like to state that whenever a disqualification case is decided by a speaker, his tenure is wholly dependent on the majority will, because if for example, if a speaker is from the opposite party and a member has defected from opposite party to the ruling party, in this case the speaker is under a fear, because if the ruling party has proceeded any disqualification petition, that is a resolution, if it is passed by the majority party, then his tenure will be cancelled, and that because his tenure is under a stake, he is under a pressure to go with the majority view of the parliament or state legislative party. Thus, the council would like to state that his tenure is wholly dependent on the majority will. Thus, his decision is said to be biased, Your Lordship.
Madam, we have to go by the majority, right?
Yes, Your
Now,
Lordship.
in the election itself, the majority party only wins.
Yes, Your Lordship. But the council would like to state that whenever it comes to adjudicating an issue with regard to disqualification, it should not go by the majority will, because it is the basic principle that nemo judax in causa states that a judge is disqualified from determining any case in which he is highly suspected to be biased. Based on this ground, the council would like to state that paragraph 6 is violative of Article 21 of the Constitution, Your Lordship.
Council, are you challenging this total 10th schedule itself, or otherwise the para 6 of the ultra words of the para 6?
The council would like to constitutionally make invalid, Your Lordship. The council is
Total
arguing for paragraph 6.
No. Are you concentrating only on para 6 or other total 10th schedule? All provisions.
In the, paragraph 6, Your Lordship. This council number 1 deals with paragraph 6.
Okay.
Much obliged, Lordship. Also, the council would like to state the case of Balachandra versus Yediyurappa. Here, the speaker has favored a member of the parliament unabashedly, and the speaker has failed to give reasonable time to respond, Your Lordship. Also, in the case of Sudhakar versus Jeeva Raju, the Supreme Court set aside the speaker's decision because it violated the principle of natural justice. In these two cases, it is said to be the responding time, but the speaker has given only 3 days time period to respond. So it is against the Article 21, Your Lordship. Thus, as the paragraph 6 does not contemplate with the time period to which the speaker has to decide with regard to disqualification of defection, the speaker is misusing the power. Hence, the council would like to state paragraph 6 is violative of Article 21, and also it affects the basic structure of the Constitution. Thus, it does not have any independent adjudicatory machinery, Your Lordship. If the Lordships are satisfied, the Council would like to invite Council number 2 to proceed with third and fourth issue, Your Lordship.
This how you correlate this para 6 to Article 21?
Because Article 21 states that a procedure that is prescribed by law should be fair and reasonable, Your Lordship. If this procedure, when we give, that is the power that is we are giving to the speaker, is not fair, Your Lordship. Hence, Article 21 is violated in the present case, Your Lordship.
Article 21 basically deals with the right to live with dignity and also forth. And you are
Yes, Your
relating this
Lordship.
para 6. How does it affect this article para 6?
Article 21 also speaks about the principles of natural justice. That is, the two principles is that nemo judax in causa, that no one should be his own judge, or the rule against bias should be avoided. And to hear to other party is also one of the principle of natural justice. We should give an opportunity for the other party to state their reasons, Your Lordship. So based on this ground, paragraph 6 is violative of Article 21, Your Lordship.
To the extent of principles of natural justice, you may be right, but Article 21 just we are not convinced on that point. Anyhow, okay, go ahead.
Yes, the Council now would like to invite Council number 2 to proceed with the third and fourth issue. Much obliged.
Go ahead, Council number 2.
Good morning, Your Lordships. This is the Council number 2, appearing on behalf of the petitioner in the case of Janaseva versus Union of India. The Council will be dealing with a third issue, that is, whether the inclusion of 10th schedule is violative of the basic structure doctrine of the Constitution. Fourth issue, whether the 10th schedule violates the rule of law under Article 14, 19, and 21 of the Constitution. Also, the two sub-issues under fourth issue. 4.1, whether the exempted cases and non-exempted cases under paragraph 4 of the 10th schedule is based on the intelligible differentia and reasonable classification under Article 14 of the Constitution. 4.2, whether the paragraph is violative of the parliamentary democracy under Article 19, read along with Article 105 and 194 of the Constitution. If Your Lordship permit, the Council would like to continue with the issue in hand.
Go ahead.
Please go ahead.
Much obliged, Your Lordship. The third issue is whether the inclusion of the 10th schedule is violative of the basic structure doctrine of the Constitution. The Council would like to begin the arguments by stating that basic structure doctrine is a judicial creation, whereby certain features of the Constitution of a country are beyond the limits of the amending powers of the Parliament.
1 minute, 1 minute, 1 minute. You
Yes,
are
Your
saying
Lordship.
the basic structure has been a creation of the judicial structure, you said. Please clarify on that.
Much obliged, Your Lordship. The Council is stating that the basic structure doctrine is a result of the judicial interpretation that happened in the 1947, Your Lordship.
1947 judicial or Constituent
After the
Assembly?
after the independence of India, the Constituent Assembly, and it is a result of the judicial proceedings, because Constitution deals with the laws of the land, and the Constitution is given to the courts, and the courts has the right
No,
to contend
I,
against
I,
any of the. Yes, Your
I am
Lordship.
wanting to know whether this is a creation of the Constituent Assembly or the judiciary. And if it
The
is
Constituent
judiciary,
Assembly, Your Lordship.
when was it?
It's a Constituent Assembly, Your Lordship.
So it is not judiciary.
I have no, Your Lordship.
Right.
I apologize for
Go
the
ahead, go
mistake.
ahead. Right.
Yes, Your Lordship.
Go
Whereby
ahead.
certain features of the Constitution. Yes, Your Lordship. An illustrative list was provided in Keshav Nanda Bharati case, but the Council would like to highlight a statement as quoted: a sovereign democratic republic, parliamentary democracy, and three organs of the state certainly, in my view, constitute the basic structure. This was the statement given in Keshav Nanda Bharati case. In this case, Your Lordship, the disqualification of the ministers under paragraph 2, subpara 1, clause B, violates the principal features of parliamentary democracy. This provision violates the right of the elected representative to independently represent their constituencies. This restriction hampers their ability of the elected member to make independent decisions on crucial matters which concerns a specific constituency. Moreover, in the Constituent Assembly Debates, Volume 7, Dr. Ambedkar has stated that the framers of the Constitution recommended parliamentary form of government. It is to ensure more responsibility than stability. Therefore, this paragraph poses a threat to the accountability of the elected members towards their respected constituency. Your Lordship, it is to be duly noted that there are three major aspects of the 10 schedule. One is regarding the disqualification of the members on the ground of defection under para 2. Second one is regarding the exceptions for defection, that is merger in paragraph 4. And lastly, the role of the speaker in paragraph 6. Moving on to the second part of the argument, that, Your Lordship, paragraph 4 provides the exception to disqualification of the ministers on the grounds of mergers. Mergers happen when 2 by 3 of the political party decides to join another party or function independently. This grants the political majorities the ability to exploit the situation and seize control of the existing government. This act neither shows accountability to the people nor shows stability in the existing form of government. Also, it should be noted that, Your Lordship, the defections under merger alienate the general public from the electoral process, further breaching the social contract between the elected representatives and voters. Allowing group defections under the guise of merger infringes upon the democracy's core values, as voters lose their say when elected representatives decide to align with parties holding diametrically opposite political ideologies. Thirdly, the position of the Speaker. The Council would like to reiterate my co counsel's argument that the powers vested in the Speaker is not the intent of the constitutional makers. Also, the lack of judicial review in the 10th schedule erodes the fundamental principles of fairness, accountability, and constitutional adherence within the anti defection framework. Here, the voter is taken for granted, and there is no recourse in law for a voter to take action against a legislator if he merges with another political party or doesn't support motions that is actually beneficial to the constituency rather than listening to the party's decision. Therefore, it is humbly submitted through the above arguments that the then schedule violates the principles of parliamentary democracy and judicial review, which forms a significant part of the basic structure of the Constitution. Henceforth, the Council pleads to declare the 10th schedule unconstitutional in the eyes of laws. If your Lordship have no query, the Council would like to move on to the fourth issue.
Yes, sir. I have no questions.
I have nothing. Go ahead.
Fair enough.
Go ahead.
Proceed.
Much obliged, Your Lordship, much obliged. The fourth issue is whether the 10th schedule violates the rule of law under Article 14, 19, and 21 of the Constitution. One of the aspects of Article 14 is that it prohibits arbitrary and discriminatory actions of the state. Disqualification of a member due to their disobedience to the party whip is unconstitutional and arbitrary, as it is used to stifle dissent within the party. This also violates the freedom of speech under Article 19. In Sri Rajesh Verma versus Sri Mohammad Shahid Aklik, BSP, the speaker held that if a member of the party opposes his original party in public, this act would be deemed to be a resignation from the party. Here, under defection law, if the minister resigns from a party, he would also be disqualified from the House. As an elected representative of the House, the minister, as the voice of the people, should be given the rights to express his dissent to the decisions of the party in order to maintain justice and curb arbitrary party will.
1 minute.
The
1 minute.
disqualification. Yes, Your Lordship.
I would like to have a clarification. In BSP's bylaw, what is it saying? He is automatically resigned.
Yes, Your Lordship. If he
So when
opposes an or much obliged, Your
go ahead,
Lordship.
go ahead. What are you saying?
If the member of the party opposes his original party, the party which he is in public, this act would be deemed to be a resignation from the party.
That's what I'm asking. So he joined the party knowing this, isn't it?
Your Lordship, a dissent can be formed at any point of time in the course of action, Your Lordship. So when he have joined the party, he might have not foreseen this particular problem, and when a problem arises, the party might take a decision against this individual elected representative's
It is not
opinion,
supposed to
and
be so,
this.
no. It is not supposed to be so because already in the party bylaw it's there that if he is dissenting the party whip, automatically is resigned.
Yes, Your Lordship. But let us consider an example here. The interstate water dispute, Your Lordship. Due to the interstate water dispute between Karnataka and Tamil Nadu, Tanjavur has suffered a lot of water disputes. So when an elected representative from Tanjavur is representing Tanjavur in the parliament, but his party decides that the decides to support Karnataka, what will the elected representative of Tanjavur would do, Your Lordship? At this point of time, the elected representative's right to individually represent his constituency is affected.
Go ahead.
Yes, Your Lordship. The disqualification proceedings under Schedule 10 violates the liberty of the elected representatives. If Your Lordships allow, the Council would like to move on to the first sub-issue under fourth issue. Much obliged, Your Lordship. Whether the exempted cases and non-exempted cases under paragraph 4 of the 10th schedule is based on the intelligible differentia and reasonable classification under Article 14 of the Constitution. It is to be duly noted, Your Lordship, that the exempted cases means that the members who have merged with the other political party under the provisions of paragraph 4 of the 10th schedule. And non-exempted cases means the members who otherwise defect as per paragraph 2 of the 10th schedule. The classification here is based on a fundamentally erroneous belief that all citizens vote solely for the party. The argument contends that this classification lacks an intelligible differentia, as the members are also elected for a reason beyond party affiliation. Citing the judgment in Ram K. Dalmia versus Mr. Justice S.R. Tendolkar, sorry for the interruption, Your Lordship. The argument emphasizes that Article 14 permits reasonable classification only if there is an intelligible differentia and a rational nexus to the object sought to be achieved. It should also be noted, Your Lordship, that there is no rational basis for treating mergers and different defections differently, as both involve a shift in the political allegiance. There is no reasonable classification here, Your Lordship. In case of Saurabh Chowdhury and others versus Union of India, which, while not directly addressing the merge and defection classification, underscores the necessity of. I apologize, Your Lordship. Which, while not directly
Is there
addressing the
disturbance from
merge
your
and
side?
defection. Yes, Your Lordship. I apologize for the disturbance, Your Lordship. It is an
Go ahead,
outside
go ahead.
event happening.
That's not your mistake, it's some technical glitch.
Yes,
We
Your Lordship.
appreciate it.
Thank
Go
you.
ahead.
In the case of Saurabh Chowdhury and others versus Union of India and others, which, while not directly addressing the merge and defection classification, underscores the necessity of rational nexus between the basis of the classification and statute's objective. Here, the argument contends that the classification lacks rational nexus, further reinforcing the constitutional invalidity of paragraph 4 of the 10th schedule. The distinction between merge and defection fairly favors the majority viewpoint, marginalizing dissenting voices. Therefore, it is humbly contended that there is no reasonable classification between merger and defection. It does not also form a nexus with the object of the legislation, that is, to curb party jumping. If your lordship permit, the council would like to move on to the second sub-issue in hand.
Yes.
Go ahead.
Much
Sir, what do you
obliged, your
say?
lordship.
You can proceed.
She can proceed, sir.
Yeah, much obliged, your lordship. The second sub-issue, whether the paragraph 2 is violative of the parliamentary democracy under Article 19, read along with Article 105 and 194 of the Constitution. Article 105 and 194 are mutatis mutandis counterparts of each other. It deals with the rights and privileges of the members of the parliament and state legislature, respectively. The rights conferred by these articles encompasses collective privileges for the entire House and individual rights of the elected representatives. However, the argument posits that paragraph 2 of the 10th schedule infringes upon the individual rights of the elected representatives by prohibiting their right to dissent from the party's decision, imposing disqualification for defection. The assertion is made that the restriction imposed by paragraph 2 of the 10th schedule is not a reasonable limitation in the interest of sovereignty and integrity of the country or public order, as stipulated under Article 19, Clause 2. Therefore, it curbs the right of the elected representatives to dissent. There is a violation of freedom of speech guaranteed under Article 19 here, Your Lordship. Also, it is to be noted that this violation extends to the entire constituency, as the elected representative is the voice of the constituency. The emphasis on stability of the government in the 10th schedule is ineffective without good governance, as stability should not compromise the freedom of speech and representation of the elected representatives. Therefore, paragraph 2 of the 10th schedule infringes upon the individual rights of the elected representatives guaranteed under Article 105 and 194. Therefore, it is humbly submitted that paragraph 2 is violative of both freedom of speech under Article 19 and the elected representatives' rights under Article 105 and 194. It is prayed before the Honorable Court to declare that 10th schedule is violative of the constitutional rights and hold it invalid.
The
If your
constitution, all these
Lordship.
fundamental rights are not absolute rights, with reasonable restrictions.
Yes, Your Lordship, but it is also to be noted that these the argument stated by the council violates the constituents as a whole. So it is not a violation of an individual person; it is a violation of the rights of the whole constituency.
Now, how does this Article 19 freedom of speech comes in the way?
Because it infringes the right to dissent in the parliament, Your Lordship. That's how Article 105 and 194 is also brought into this case, where in 105 it states that 105 states that all members of the parliament have the right of freedom of speech in the parliament. So
No,
here
but
it infringes the
what
right. Yes, Your
what
Lordship.
my brother was asking was fundamental rights come with certain restrictions, isn't it?
Yes, Your
So
Lordship.
can that be? That is what is the question is.
Here, as the Parliament, much obliged, Your Lordship. The fundamental rights have restrictions, Your Lordship, but this is also a special privilege for the elected representatives because it is the right to speech in the Parliament and not outside the Parliament. So, Article 105 should also be taken into account.
Sir, time
Yeah,
dispute.
it's all right. It's all right. How does the
Yes,
defection?
Your
You support the defection, then
No, Your Lordship, I do not support the defection. I state that the defection laws are arbitrary and does not arbitrary and violates the basic structure of the Constitution, and therefore must be amended probably or brought in a new law for defection.
what do you suggest? What do you feel that? What is the what is the best way to come out of this?
Uh, Pardon, Your Lordship.
Now you say the defection there should be a separate law to be framed and all.
Yes, Your
What is your
Lordship.
prayer? What is your prayer?
Yes.
A prayer. My prayer is to hold this petition maintainable and to hold the 10th schedule unconstitutional. So if the court declares that the 10th schedule is unconstitutional, the parliament would be forced to bring in a new law in furtherance of defection, and such a law could also be incorporated in such a way that it furthers all the requirements of today.
Fine.
If your
Okay, thank
lordships
you.
are happy with the queries, the council would like to continue with the prayer of the petitioners.
Yeah, yeah, please.
Yes, your lordship. Therefore, in lights of the facts stated, issues raised, arguments advanced, and authorities cited, it is humbly prayed that this Honorable Court be pleased to hold, adjudge, and declare that the petition is to be held maintainable. The office of the Speaker does not satisfy the independent adjudicatory mechanism. The inclusion of the 10th schedule in the Constitution is violative of the basic structure of the Constitution. The 10th schedule violates the rule of law under Article 14, 19, and 21 of the Constitution, and it is unconstitutional. The Honorable Court may pass any order or decree as it deems fit in the interest of justice, equity, and good conscience. And for this act of kindness, the petitioner shall be duty bound, ever humbly pray. It was an honor arguing before the court. Achuk. Thank you, Your Lordships.
Good.
Right, sir, can be proceeded further?
Yeah, now let the courtmasters, the respondents can start, isn't it?
Yes, sir.
Yes, sir. Am I audible?
Yes, yes.
Yes.
Greeting, Your Excellencies. The Council seeks permission to address the bench as the Lordship.
Go ahead.
Yeah, please.
Much obliged, Your Lordship. I am the Council number 1, representing the side respondent today in the matter of Jan Seva versus Union of Indigo. I, along with my co-counsel, shall be taking 30 minutes of the Chamber's precious time. Council number 1 would be dealing with the first issue, whereas Council number 2 would be dealing with the second issue. Under first issue, the council would be dealing with the 3 sub-issues. The first issue is that the amended 10th schedule the first issue is that the disqualifications of members of parliament and legislatures of state as per para 2 of 10th schedule is not violative of the basic structure. Under this, there are 3 sub-issues. The first one is that the amended 10th schedule is strengthening the parliamentary democracy. The second sub-issue is that the amended 10th schedule does not violate the freedom of speech and expression. The third sub-issue is that it does not violate the principle of natural justice. Proceed.
Now, what do you, when you say about the basic structure, how do you explain basic structure?
Indeed, Lordship. These have been mentioned in my first sub issues. I'll be dealing with that under that.
No, you come on. You don't have to go to that. You can just answer. And then
Indeed,
we'll
Lordship. Indeed, Lordship. Lordship, as this doctrine of basic structure was given in the case of Keshwan and Bharti case, in that very judgment, the judges, under the judgment, there were few points that were given which tells what does actually the basic structure is. Under that, the parliamentary democracy and the parliamentary democracy, the limitation on the few limitations on the power of the legislature, and these are the points that has been given under the basic structure, Lordship.
proceed.
Indeed, Lordship. Dealing with the first sub-issue, that the amended 10th schedule is strengthening the parliamentary democracy. Lordship, the political parties is implicit in the democratic form of government, and they are the sine qua non of the parliamentary democracy. If the Lordship pleases, then kindly refer to citation number 3 of the Moot Memorial, where there is a book called as in Political Party and Democracy by the Casey Stokes. He has very specifically stated that political parties are endemic to the democracy. And in political party, they actually share the beliefs or the and if they will give the freedom to the members to vote as whatever they want, then that will lead to the diminishing the image of the political party in the eye of public, and the party will lose the confidence in the eye, and therefore it is very necessary to maintain this maintain the political party. And if the Lordship pleases, then kindly refer to citation number 8, where in the case of Quixote Holhan versus Velichu, the court has said that the provision which disqualify the members on voting against the party whip actually strengthen the fabric of the political democracy. How? First, by curbing the unprincipled and unethical political defection. Therefore, Lordship, we can say that 10th schedule is strengthening the democracy by ensuring the survival of the political party. Moving with the second sub-issue is that the amended 10th schedule does not violate the freedom of speech and expression. Lordship, the freedom which is given under Article 194 is not absolute and it can be curtailed. As if the Lordship pleases, then kindly refer to citation number 10, where in the case of Prakash Singh Badal versus Union of India, it was said that curtailment of freedom under 10th schedule is not violative of Article 105. Lordship, the while making these laws, the framers of the constitution never wanted to confer an absolute right of freedom of speech and expression on the members of a political party. And it is to be noted, Lordship, that para 2 of the 10th schedule merely restricts the freedom of speech of legislature, and it does not violate the right as given under Article 19, Clause 1, that is the right given under the Constitution as a fundamental right of the members. Therefore, it does not take complete freedom of speech and expression.
1 minute. You say absolute freedom is not there, but I would say the framers of the constitution at that point of time, they have given absolute freedom, and they were expecting that absolute freedom will not be misused, which is not seen today. That's a difference. Because if you go to during the Rajendra Prasad, the Prime Minister, Lal Bahadur Shastri, the Prime Minister, when he was the railway minister, due to an accident, he had taken the moral responsibility and resigned. That shows those days the constitution was written giving the absolute freedom and that it will not be misused.
Indeed, Lordship. Lordship, seeing these circumstances only, the amendment has came of the 52nd Amendment, because the time has not been same as it was during those days.
So what I'm trying to say, when it is brought in now, is it saying that it is not coming with without? Is it saying it is coming without absolute freedom? No,
Uh, now there
absolute
is
freedom
no,
is still there.
pardon, Lordship.
Absolute freedom is still there, isn't it?
Right now, Lordship, absolute freedom is not there, because if you will go against your party whip, against the decision of the party, then the anti-defection law comes, and therefore we can say that it is not absolutely that you are not being given the absolute power to vote as whatever you want.
Okay.
If the lordships are satisfied, the council seeks permission to
Go ahead.
proceed.
Proceed.
Much obliged, your lordship. Lordship, here in the anti-defection law, the dissent of the members is also accommodated. It is not completely curtailed. If the lordship pleases, then kindly refer to citation number 12 of Gopal Krishna Belur versus B.S. Yadurappa. Here, lordship, the judges have said that the dissent is the essence of the parliamentary system. However, lordship, when the dissent becomes defection, then disqualification is incurred. Lordship, under the 10th schedule, the members are disqualified for voting against the party only when they fail to take prior permission of the party, or their actions are required to be condoned by the party within 15 days of their from their voting or abstention. Therefore, we are not completely excluding the dissent. There are two exceptions which have been accommodated under the 10th schedule, and we do give respect to the dissent of the members as well. Next is that next sub issue is that it does not violate the principle of natural justice. The principle of natural justice contains the two principles in itself. First is that odi altrum partem, which implies that no one should be condemned unheard. Second is that nemo judex in causa sua, that means no one should be the judge in its own case. Lordship, if the Lordship pleases, then kindly refer to citation number 9, where in the case of Charan Lal Sahu versus Union of India, here it has been said that statutory exceptions can be provided in principle of natural justice where no adjudication is needed and no prejudice is caused to anyone. Lordship, as given under para 2
1 minute,
of
madam. 1 minute. Now the petition is because prejudice happened. That is why the petition is here. So this citation does not hold water.
indeed, Lordship. Lordship, as given under para 2 of the 10th schedule, its first point says that if the member voluntarily gives up his membership of such political party, then the disqualification will be made. Lordship, there are many circumstances where the proceedings is just very formal. Like in case if he's voluntarily giving his membership, then in that case, coming up of the anti-defection proceeding against him is very natural. And Lordship, as uh, now it is not now the speaker does not have arbitrary powers to adjudicate as whatever they want, because if there has been a recent case of Keshav Meghachand versus Speaker of Manipur. Lordship, under this case, what had happened was that the speaker was not giving the decision, and then the court has given the speaker 3 months time to give the results. On failure of that, the court has came.
1 minute, madam. I would like to know which is superior. If this is the case, if court is directing the speaker to take a decision in 33 months, is it not interfering into the legislature?
Indeed, Lordship. Lordship, in the case of Kyoto Holland, the court has said that the judgment was that before this decision of the speaker, the court cannot intervene into it, and when the matter is pending and the speaker is not giving the decision, then they are coming into, and therefore it is actually saving the natural rights of the members, and it is not violating that. Therefore, in both the circumstances, first the speaker has the power, and on failure of that, the court will come in. Because Lordship, it is to be noticed that in present case there are the courts are already burdened with lot of cases, and in case where it is very formal to adjudicate upon, in that circumstances the court does not think to intervene in between. Because Lordship, before when the 10th schedule was what was there was paragraph 7 which says that the bar of jurisdiction of courts. But Lordship, this paragraph was declared invalid in the case of Kyoto Holland versus Zalichu. Therefore, in the 10th schedule also, they keep on amending the things so that it will be in accordance with the running of time, and so that it does not invalidate any of the natural rights, and therefore we can say that it does protect the natural justice of the members. And therefore, Lordship, we can say that the statutory exceptions of the natural justice under 10th schedule is justified, as the removal of speakers in the matter of disqualifications becomes necessary. If the
I
Lordship,
think petitioners are basically questioning that article, para 6, the powers of the speaker. And what is your answer for that?
You are also agreeing to the fact that speaker does not have absolute power, isn't it? He cannot be above because he will be biased. What do you say for that?
Indeed, not lordship. Lordship, what we are trying to say is that the speaker also has some, like, under the Keshwar and Bharati case, it was said that the legislature does not have unbridled power. Incorporating that in our arguments, we are saying that the speaker also comes under the ambit of the constitution, and firstly, he has the right to adjudicate upon the disputes. And in case something goes wrong or the decision is not fair, then in that case the judiciary comes in. But before that, the speaker will have the power. If the lordship pleases, then I would like to share the screen of one judgment.
Please
Go
go ahead.
ahead.
Much obliged to lordship. Lordship, this is a case of Gopal Krishna Belur versus B.S. Yedurappa. Lordship, in this case, it was said that the speaker is the only authority competent to decide whether a legislature had incurred the disqualification under 10th schedule of the constitution. The proceedings are to be held by the speaker alone and no one else, and if due procedure has been followed based on correct analysis of facts, the order passed by speaker cannot be assailed. And in line with the with this
But
judgment,
is it not giving an absolute right to the speaker to take a decision sitting on his own? So is it fair?
That's right. And you mean to say that speaker decision cannot be subjected for the judicial review?
lordship, if the decision if the judges feel that it is not violating the natural right and everything is being done in accordance with the procedure that has been established under the 10th schedule, which the speaker takes oath while coming up to that position, and if it is not getting violated, then in that case the judiciary does not comes in, because there is already the separation of power that has been established. So neither legislature or the judiciary wants to intervene under the sphere of each other.
No, that's what I'm asking. Uh, how do we know that whether he has taken a right decision or not?
Correct.
Lordship, as given under the para 2 of the 10th schedule,
In the citation which you said, it cannot be assailed, you said. But my question is, if the decision is wrong, then what happens?
Then it has to be questioned.
Lordship, first of all, the power is to the speaker, and if it is completely arbitrary, like if the members believe that it is completely arbitrary, and then they somehow go to they somehow knock the door of the court. And as the procedure that has been given under para 2 of the 10th schedule, first point is that if he voluntarily gives up the membership, second is that if he votes or abstains from the voting. So in accordance with these procedures, the speaker adjudicate upon the dispute, and he also takes the while taking up his office, he takes the oath to to go with these proceedings, as in like 10th schedule is trying uh, to be in the line of the contemporary India, what is going on, and therefore we are saying that it is not violating the basic structure of the constitution, and it is not violating natural justice, and it is not violating the speech and expression, and it is strengthening the parliamentary form of democracy which the indigo is based on. If the lordships are satisfied with the arguments pleaded, The council number 1 would like to invite the council number 2 to proceed with the issue 2.
Yeah.
It was
Go
pleasure
ahead.
arguing before the court. Thank you so much.
The
Greetings to
council
the
number
bench.
council number two, before you start, because there is, they have to address the present scenario, what is happening in Indigo or India, whatever it is there. Now, how to overcome this situation, you have to address this. People get elected with great hope by the people. Sorry, the MLAs or MPs. Then thereafter, this defection, shifting the parties and whatever is happening in the present scenario. Please also address on this. You can go ahead.
Much obliged indeed. Greetings to the bench. Before I proceed with my submission, I would like to confirm if I'm both audible and visible properly.
Yes, yes, you can go ahead.
Much obliged, Your Lordship. Uh, in continuity to the queries raised by the Honorable Bench, I would like to seek permission to begin with the pleading for the second issue and answer the queries raised by the Honorable Bench.
Go ahead, go ahead.
Your Lordship, the second issue, that the Speaker or Chairman under Para 6 of the 10th Schedule satisfied the requirement of independent adjudicative machinery and his subjectivity to judicial review is appropriate to the queries raised by the bench. I have two submissions in this regard. Addressing the sub-issue that Speaker or Chairman decisions subjectivity to judicial review, the Supreme Court in Dr. Kashinath G. Jalmi and another versus the Speaker has clearly stated that the Speaker's or Chairman's decisions under 10th Schedule are final. The Supreme Court in Kyoto Holoan versus Zachilu and others clarified that the scope of judicial review would be limited to examining whether there has been a violation of constitutional mandate, malefides, non-compliance with the rule of natural justice, and perversity. Further, the principle of quod timit action, which translates to because he fears or apprehends, is preventive in nature, is not applicable in the context of 10th Schedule, as judicial review is not available prior to Speaker's or Chairman decision, as established in the case of Ashwin Lakshman Bhai Kotwal versus Honorable Speaker Gujarat State. The The Para 7 has already been declared inoperative and unconstitutional. The Para 6 is the only thing that leaves room for doubt. The expression shall be final is the point of contention. The final connotes that presiding officer has the final power of consideration of evidence. And Supreme Court and the Honorable High Court under judicial review can make a reassessment of the facts. So it becomes problematic. The Nabam Rabia case on authority of speaker was challenged in the Subhash Desai case, and it's referred to as 7 judgments. It's sub judice, so yet it's not clear, and only court on the honorable court can become the source to clear it. Further, Your Lordship, the Supreme Court has power to issue directions or orders or writs which may be appropriate for the enforcement of any of the fundamental rights under Article 32. The provisions of the 10th Schedule have been held by the Honorable Supreme Court in the earlier mentioned Kyoto Holon versus Achilu not to violate the freedom of speech, vote, and conscience of the members. This is in line with the arguments raised by my co-counsel as well. These provisions aim to strengthen the fabric of Indian parliamentary democracy by curbing unethical political defections. Furthermore, the freedom of speech of a member, while fundamental, is not absolute and is subject to constitutional provisions and the rules regulating the procedure of the House. Additionally, the parliamentary privileges under Article 105 are violated by the 10th Schedule, as it does not lead to any court proceedings, are not violated by the 10th Schedule, as it does not lead to any court proceedings, thus safeguarding the guaranteed immunities. Uh, a recent instance that has the limited scope of this judicial review could be seen as compromising the interest of people of any state. The 10th Schedule was designed to curb political defections and ensure stability within the parliamentary system. But when judicial review is limited, there might be instances where the Speaker's decision, although not arbitrary, may not align with the broader democratic principles and the interest of people of the candidate involved. A recent instance that has brought the issue to the forefront is the political crisis in the Maharashtra during 2022. A crisis arose when the faction within the Shiv Sena party led by Eknath Shinde rebelled against the party leadership. The Deputy Speaker of the Maharashtra Legislative Assembly disqualified the rebel MLAs, which was then challenged in the Supreme Court. Addressing the sub-issue
Is
that
that citation there with you? Can you share me that citation?
I apologize, Your Lordship. The Council will present in the subsequent written submission by the end of the arguments.
Not the written submission. I would like to know, you are making a submission, isn't it? Once this is over, there is no written submission.
The Council apologizes in this regard.
Because what I am observing is certain cases, the citation what you quote, and it has not been able to be produced. That's why I'm asking. If it is not available, it's not available, we'll proceed.
I apologize in this regard. The Council will seek request assistance of Speaker 1 in this regard. She will supply the citation as I proceed with the argument.
Yes, she can do that.
Much obliged.
Yeah.
Much obliged, Your Lordship. Addressing the sub-issue that the Speaker satisfied the requirement of independent adjudicating machinery. The 10th schedule validates the Speaker's power to adjudicate disqualification cases with a clear mandate that the decision is final as stated before. This is further reinforced by paragraph 6 aligning with the proceedings under Article 122, which prohibits the courts not to inquire into proceedings of Parliament and prohibiting courts from questioning the validity of parliamentary proceedings on procedural grounds. In the landmark case of Kyoto Holon versus Achilu, the Supreme Court upheld the 10th schedule's constitutionality, affirming the Speaker role as a fair adjudicator. Despite concerns of political bias, this decision emphasizes the trust placed in Speaker's capacity to act impartially and independently in accordance with the Constitution. The argument raised that the party allegiance may corrupt or make a speaker biased is not in line in questioning such a high constitutional post, since the if the constitution does not maintain leaving party for the speaker, it also does not mandate the same for the president. Questioning high constitutional posts who align their oath to constitution is an moral impediment to the spirit of democracy of the Republic of Indigo. If it may please your lordship, council seeks permission to read out the prayer.
You come to the prayer. What is your answer for the petitioners' council that elected representative should resign? And before he says something, now vis-a-vis, they were questioning about the validity of the para 6.
Your lordship, quoting the landmark case of Kyoto Holon versus Achilu, the Supreme Court upheld the 10th schedule's constitutionality, affirming the speaker's role as a fair adjudicator, despite concerns of potential political bias. This decision emphasizes the trust placed in the speaker's capacity to act impartially and independently. Further, in line with that, there has been a prevalent practice where speakers, despite the provisions are silent on resigning from their party, have been resigning from their party on a moral grounds. Further, uh, other posts like presidential posts and governor posts are also political posts, but as soon as these constitutional high moral posts are acquired by people, they leave their party, though there is absence of provisions in this regard. So, uh, the council submits that in moral lines and in high constitutional lines, individually questioning fair adjudication and sanctity of parliamentary democracy would be violative of moral conscience of democracy.
I beg your pardon, last word, sentence. What did you say? Last sentence? I couldn't hear you.
Moral.
Line with principles of sanctity of parliamentary democracy, questioning this will harm the moral conscience of people of this democracy.
Moral.
Your Lordship, in regard to the query raised regarding the case citation, My counsel has assisted me in the same regard. May I read the citation?
Go ahead. Please share the screen, no?
Yes, Your Lordship. Please pardon for the delay.
Courtmaster grant them this time leverage. Okay.
Yes. Apologies.
Please read the relevant portion. This is regarding the governor and principal secretary. What is the relevant portion? Could you please read it for me? For us.
Lordship, this is a copy of a judgment. A copy of an order. I'll just get the copy of a judgment.
I think Maharashtra High Court judgment it should be
Yeah.
correct.
Yeah.
The Supreme Court it has not yet finalized it.
Yeah.
In your counsel petitioner, one can work out on that, but the petitioner number two, but still on the point of you say that the decision of the speaker is the final, right?
Responded, isn't it?
In uh, Your Honor, Your Lordship, in that regard, the finality, as connoted in this para 6, has been subject to judicial contention under the Nabam Rabia case. But it was further challenged in the Shubham Desai case, which has been referred to a seven-judge bench. So it's sub judice, and it's not clear, and only the honorable court will become the source to clear it.
It has to be because para 7 is no, that is struck off. What is that? Bar of jurisdiction of the courts is taken out now. The courts
Yes, sir.
courts have to, because there should be a judicial review. But leaving aside all these things, what do you feel personally? Because what is the way to come out? Otherwise, a lot of issues are happening in India now. The elected representatives are taking their stances as per their convenience, and it is nothing but a cheating on the whole people. And they defect as per their whims and fancies. What has happened in the Maharashtra is a glaring example.
Your Lordship, in that regard, the case
I wish to add one more thing. Please understand that you are a respondent counsel, but you are an officer of the court. So
Exactly.
even if you feel, you can take your stand. If you are in line with the petitioner, you can also take a stand to assist the court to come to a judicial conclusion. That's what my co-brother has been asking for. What is your personal view?
What is the solution for this?
Yeah.
So, in line with the Manipur Assembly case, my view says that no one can see the intervention of court was to prevent an anti-defection law from defeated, consequent to the abdication of constitutional duties by the abdiction. But also in the meantime, when the decision is sub judice with the speaker, the court must be given power to inquire into it so that the constitutionality of the 10th schedule can be upheld and no further question can be raised on the same.
No, the issue now is which is boiling our country is that uh, anti-defection is happening en masse. Because once a two-third majority shift their affiliation from one party to another, who is contrary to the principle of the ruling party, then the voters' rights are
Exactly.
at stake.
Sir, best example is right now, what is the Telangana as it is happening now. Even people are thinking, people may jump from one party to another and there is a chances now because that is not absolute majority the Congress party has got it.
Yes,
A common man also is able to talk about this now.
yes. But the common man is not able to act.
Correct. That's why the bill is filed and you have to answer as a government officer.
Yes, officer of the court and the government of the officer.
Uh, Your Lordship, from an ethical standpoint, the defections might be viewed as a breach of social contract between the electorate and their representative. It can be argued that the representative have a moral duty to uphold the promises and commitments they make to the constituents. On the other hand, it is also important to consider the context in which defections occur. In some cases, defections might be driven by genuine ideological differences or a belief that the party's direction no longer aligns with the representative values or the best interest of their constituents. Uh, while I don't suggest in personal belief or moral, the phenomena of political defection raises important ethical questions, uh, but it's a complex issue that requires careful consideration in line with the motivations behind what these defections drive and their impact on the democratic process. So the um, so the evaluation of the genuineness of the if it is a genuine ideological difference or a change in belief of a party direction uh, must be put into test, uh, not just uh, not just adherence to the um, black letters of law would serve the same. Uh, Judgment of a genuine causes must also be taken into regard.
Still we are solutionless now.
But I appreciate your shift in the view on the ethical side.
That's right. That's right.
If it may please your lordship, council seeks permission to read out the prayer.
Go ahead.
Wherefore, in the light of the issues raised, arguments advanced, reasons given, and authorities cited, it is most humbly prayed that it may be pleased to, firstly, declare that the disqualification of members of parliament and the legislature of state, as per para 2 of 10th schedule, is not violative of basic structure of constitution. Secondly, declare that the speaker or chairman under para 6, the 10th schedule, does satisfy requirement of independent adjudicated machinery and is subject to judicial review by the Supreme Court under Article 36 and 32 of the Constitution, and or pass any other order, direction that the Honorable Court may be pleased to grant in the interest of justice, equity, and good conscience.
1 minute. What is your second last prayer? I mean, the last prayer?
Declare that the Speaker or Chairman under para 6 of the 10th schedule does satisfy the requirement of an independent adjudicated machinery and is not subject to judicial review by the Supreme Court under Article 136 and 32 of the Constitution.
You mean to say it is not review, it cannot be reviewed?
Your Lordship, the argument was raised in to raise that the judicial review, the subjectivity to judicial review has been limited to the scope that it has only the post decision. The arguments were in line that the judicial review must be extended to uh, sub, uh, to prior decision making also.
Okay.
And also you say that not subject to judicial review by Supreme Court under Article 136 and 32.
So, in line with the question of Article 32, we raised that Article 32 gives the power to issue directions or order when uh, there is a question of enforcement of any fundamental right. My co-counsel submitted that the time schedule is not violative of fundamental rights. Therefore, the question of going to judicial review under Article 32 is not went on, since there is no violation of fundamental right at the first place.
Both of you are not argued on the point of the locus of the petitioner on filing a bill. . You can go ahead.
and or pass any other order, direction that the Honorable Court may be pleased to grant in the interest of justice, equity, and good conscience, all of which is respectfully submitted, and for this act of kindness the respondent duty bound shall ever pray. Thank you, Your Lordship. It was an honor arguing before this honorable bench.
Is the time up, Court Master?
Yes, sir.
Now is the time for us to give feedback, right?
Feedback, I think a rebuttal.
Lordship.
Any rebuttal is there?
Yes, Your Lordship.
Go ahead.
With much due respect to the bench, the counsel of the petitioner would like to recite the rebuttals for this proceedings. Firstly, the counsel would like to contend that there is no issue raised pertaining to the maintainability by the respondent. This is a clear indication that the respondent agreed that there is sufficient grounds for the petition to be held maintainable.
That the rebuttals to be by the petitioner counsel?
Yes.
Yes, Your Lordship. I was asked in the beginning
Yeah,
of
yeah,
the.
Oh, right. I'm sorry. I thought you are respondent. I'm sorry.
yeah.
No worries, Your Lordship. Thank you, Your Lordship. Much obliged. Secondly, the respondent's arguments are in violation of Article 105 and 194. The right to vote is a form of freedom of speech and expression, as it expresses the party members' right to dissent. Moreover, paragraph 2, subpara 1, clause B violates the rights given under Article 105 and 194, where it curbs the freedom of speech and expression and right to vote in the parliament or state legislature. Thirdly, the argument of the respondent's first issue is based on a fundamentally erroneous belief that voters vote on the basis of the party alone. Therefore, the respondents focus only on the loyalty towards the political party, but not about the voters' right under Article 14, 19, and 21. The major feature of the parliamentary form of government is a representative government. Here, by focusing on the loyalty towards the political party, the respondents fail to address the voters. Moreover, the constitution or law does not exist for the political party, but for that of the people. Therefore, the survival of the political party should not be put as the first or major concern. Furthermore, the respondent stated that in Keshan Singh was a speaker, prescribed 3-month limitation for the speaker to decide upon any cases regarding defection. But the respondents have conveniently.
Let me interfere now. Let me interfere now. Your rebuttal should be restricted to certain points only.
That's
now
right.
you are continuing with your argument.
You have to give a clarifications for the any.
That's it.
Indeed, not your lordship. The further rebuttal is that in Keshan Singh was a speaker.
No,
The
you please
respondent
tell me
stated that.
only 1 minute.
Yes, Your
Your
Lordship.
rebuttal should be 1, 2, 3.
Much
Point
obliged,
wise,
Your Lordship.
not based on certain citations and all those things. That means you are again going for a petition argument. He has raised certain clarifications. If that is wrong, you just tell 1, 2, 3. This is wrong according to him in this, like that.
Uh, that is what the council is trying to tell your lordship, that the respondents said that 3 months time has been prescribed, but they have ignored the second part, which states that facts and circumstances must be considered before sticking to the 3-month time period. Therefore, it states that the speaker does not necessarily have to decide every cases within the 3-month time period. Also, the respondents quoting the Quixote Hooligan case, which was decided 28 years ago in 1992. This is a sufficient time for a significant change to happen. Therefore, the petitioner pleads that to the court that the petition to be held maintainable and consider that 10th schedule should be held unconstitutional. Uh, as a part of the individual opinion of the council would also be happy if the court provides direction to the parliament to amend the law, even if it is not holding the 10th schedule unconstitutional. Much obliged, Your Lordship.
Venkata garu, you can
Sir,
start the feedback.
yeah. Now because now the finality I could not find any because solution now the laws are there, but as a judge we personally do not like that the judicial review cannot be taken out. Now speaker's decisions cannot be final. Now because these are all political party. Speaker is none other than is not a neutral person. He belongs to one or other party. Naturally, because once this kind of situations arises, the best part is either whenever the defection is happening, either the elected representative should resign and do the things, and he should be punished for the resigning also because the country has spent a lot of amount on the elections and all, and again re-election is a big task. And the question is now, if that is the kind of see, as somebody has advised out of one of your speakers that there should be a new law should come out. Now, if that kind of strictures are put on, I don't think anybody would dare to resign and shift the parties from one party to another. So the best solution is it should be decided by way of judicial review, or if not governor and president, because one of the speakers said that they are also belongs to one or other political party. Either a common person or retired chief judges are that could be the best solution. And anyhow, because all the speakers have put their efforts effectively, but the rebuttal could have been as my senior judge has advised, and rebuttal to them only you have to address the points which you have not addressed in the initial stage of the argument. And where the respondent have raised some new issue, then do you have to give a clarification? You can't go on arguing like that. And all of you have done well and all the best.
From my side, I would appreciate and I congratulate all the teams. All the best to go to the next round. All of you have performed well, and your presentations was mannerism and your language, everything is well appreciated, and you are very clear on the subject. That is also appreciated. And as I was mentioning, rebuttal should be to the point which has been raised new by the respondent. It is so that the rebuttal is given. So that you have to keep in mind. Otherwise, the mannerism, etc., is good. And one more thing I want to tell you is that good morning, good afternoon, all those things. This is not a school or a college. Your minus that, everything was excellent. Excellent. I would say your mannerism, everything has been technical glitch everywhere it happens. That nobody can help it. So for that, we have given that time lag for you also. I hope we have given you judicial time, and we have given you the comfortable hearing also. I wish you all the
Yes,
best.
Your Lordship.
I thank our judges, Dr. Venkat Reddy, Donthi Reddy sir, and Thomas George sir for adjudicating these semi-final rounds. Courtmaster, you can stop recording.